Hello student, welcome to the lecture on consumer protection laws affecting hotels. And after this lecture, we will be able to learn the following objectives. Understand application of Consumer Protection Act CPA, discuss about UN guidelines for the consumer protection, understand wage and hour laws applicable to hotel employees, explain state laws relating to alcoholic beverages. Let's start with a brief introduction. The Consumer Protection Act strives to protect consumers against unfair business practices, giving them greater recourse against companies that supply them with products or services. It sets out the minimum requirements to ensure adequate consumer protection and provides an overarching framework for all other laws that provide for consumer protection. It brings a number of previous disparate pieces of consumer legislation into a single document, effectively ensuring that suppliers now carry the risk and expense of goods or services that are not up to an acceptable standard. Let us now discuss the application of Consumer Protection Act CPA. Taking into account the interests and needs of consumer in all countries, particularly those in developing countries, recognizing that consumer often face imbalances in economic terms, education levels and bargaining power, and bearing in mind that consumers should have the right of access to non-hazardous products, as well as importance of promoting just, equitable and sustainable economic and social development. These guidelines for consumers' protection have the following objective: to assist countries in achieving or maintaining adequate protection for their population as consumer, to facilitate production and distribution patterns responsive to the needs and desire of consumers, to encourage high levels of ethical conduct for those engaged in the production and distribution of goods and services to consumer, to assist countries in curbing abusive business practices by all enterprises at the national and international levels which adversely affect consumer. The provision of the CPA are far-reaching and affect not only what one offer customer but also how one offer it. The regulation can be roughly grouped into the following areas. Language. The Act does not specify that particular official languages have to be used when giving consumers information about the product or service. It does stipulate that the language has to be appropriate for the people at which the product or service is aimed. Agreements. In terms of the CPA, any agreement that seems excessively one-sided in favor of anyone other than the customer can be ruled to be unreasonable and unjust. Once this happens, the customer is no longer bound by that agreement. Contract terms and renewals. The CPA includes a lengthy description of terms and conditions that says could be considered unfair or unreasonable and should not be included in a contract or agreement. Cooling off period. The good news for impulse buyers, but not unnecessary for direct marketer, is that consumer who buys something in a transaction that was not initiated by them, then they have a 5-day cooling off period in which to return the item, refunds, repairs and warranties. The Act creates what is known as implied warranty, which means that producer and distributors are expected to supply goods that meet the standards and general quality that is envisaged in the Act. Overbooking, reservation and cancellation. Consumers still have the right to cancel a booking or reservation, and one has a right to charge a cancellation fee. The Act stipulates that this must be a reasonable fee based on how early the cancellation was made and how easy it will be for one to fill that now empty spot. Marketing. Consumer will be breathing a sigh of relief at the provision that enables them to preemptively block any direct marketing attempts, whether this is by email, phone or printed material in the post. In terms of the CPA, a consumer has to first be informed that a company wants to market to them directly. Safety monitoring and recall. The Act offers a new take on safety monitoring in that it requires the National Consumer Commission to promote the development and adoption of codes of practice that guide how different industry monitor the safety of their products. One's trading name. Customers deserve to know exactly who they are dealing with. The Act stipulates that one can no longer use a trading as name that is not related to the registered name. Disclosure and intermediary services. Consumers now have the right to know about any money that an intermediary, such as an agent and possibly a distributor, makes from a sale. UN Guidelines for the Consumer Protection. The United Nations Guidelines for Consumer Protection (UNGCP) act as an international reference point of the consumer movement, but with new developments in technology and business practices, there is a strong argument for revising them to ensure they are still relevant to the challenges facing consumer. The guidelines were adopted by the UN in 1985 after 10 years of campaigning by CI. They gave important legitimacy to the principle of consumer rights and practical support and guidance for developing national consumer protection legislation. In 1999, they were updated with a new section on sustainable consumption and production to reflect environmental concerns emerging during the 1990s. How the Act was enacted. The Act was passed in Lok Sabha on 9 December 1986 and Rajya Sabha on 10 December 1986 and assented by the President of India on 24 December 1986 and was published in the Gazette of India on 26 December 1986. The Act Consumer Protection Act India 1986, an act to provide for better protection of the interests of consumer and for that purpose to make provision for the establishment of consumer councils and other authorities for the settlement of consumer disputes and for matters connected therewith. Consumer. A person is not a consumer if he purchases goods for commercial purpose or resale purpose. However, a person is consumer if he or she purchases goods for the purpose of earning his livelihood by means of self-employment. Consumer as defined USEC 2 Clause 1 Clause D of the Act. Consumer means any person who buys any goods for a consideration which has been paid or promised or partly paid and partly promised under any system of deferred payment and includes any user of such goods when such use is made with approval of such person, but does not include a person who obtains such goods for resale or for any commercial purpose. Why the Consumer Protect Act? It is because a consumer has a right to safety, information, choose, behead, redressal, consumer education. Unfair trade practice. Adopting unfair methods or deception to promote sale, use or supply of goods or services. Consumer need protection against restrictive trade practice, price fixing or output restraint. Delivery or flow of supplies to impose unjustified cost or restriction on consumers. Collusive tendering, market fixing territorially among competing suppliers, depriving consumers of free choice, fair competition. Consumer need protection against defects. Any fault, imperfection or shortcoming in the quality, quantity, potency, purity or standard which is required to be maintained by or under any law for the time being enforced or under any contract express or implied or as is claimed by the trader in any manner whatsoever in relation to any goods. Deficiency. Any fault, imperfection, shortcoming or inadequacy in the quality, nature and manner of performance which is required to be maintained by or under any law for the time being enforced or has been undertaken to be performed by a person in pursuance of a contract or otherwise in relation to any service. Where should one complain? If the value of the services and compensation asked for is INR 5 lakhs, then one can complain to the district forum at the district headquarters. INR 5 lakhs and within INR 20 lakh, the complaint can be filed before the concerned state commission at the state capital. What is method of filing a complaint? A complaint shall be instituted in the district forum within the local limits of whose jurisdiction the opposite party or any one of the opposite parties where there are more than one or the defendant actually and voluntarily resides or carries one business or has a branch office or personally works for gained at the time of institution. Who can file a complaint? A consumer, any registered voluntary consumer organization, the central government, the state government. When can a complaint be filed? Under the Act, a complaint can be made in writing in the following circumstances. If one has suffered loss or damage as a result of any unfair trade practices adopted by the trader, if the services hired or availed of suffer from deficiencies in any respect. What information should a complaint contain? Complaint should contain the following information: name and complete address of complainant, name and complete address of the opposite party or parties as the case may be, date of purchase or service obtained, amount paid for consideration, remedies. The forums or commissions can order the following relief: removal of defects from the goods, replacement of the goods, refund of the price paid, award of compensation for the loss or injury suffered, removal of defects or deficiencies in the services. Appeals against district forum. Within 30 days in state commission, within 30 days national commission, within 30 days Supreme Court. Wage and hour laws applicable to hotel employees. Wages and hours laws which are applicable to the hotel employees are described in various ways. The Minimum Wages Act 1948. The objective of this act is to fix minimum rates of wages in certain employments. Fixing of minimum rates of wages. The appropriate government shall fix the minimum rates wages payable to employees employed in the scheduled employment. Review at such intervals not exceeding 5 years the minimum rates of wages so fixed and revise the minimum rate if necessary. Who can file a claim petition? The employee, any legal practitioner or any official of a registered trade union authorized in writing to act on his behalf. Register and records. Every employer shall maintain the register and records as required under the Kerala Minimum Wages Rules 1958 and acted by Section 30 of the Act. Authorities appointed under the Act: Labour Commissioner, Additional Labour Commissioner IR&E, Regional Joint Labour Commissioners, Joint Labour Commissioner P. The Industrial Dispute Act 1947. The Industrial Dispute Act IDA of 1947 states that firms employing 300 or more workers required to obtain government permission for layoffs, retrenchments and closures. Types of industrial dispute. There are two types of industrial dispute: interest dispute and rights dispute. Interest dispute relate to determination of new wage level and other condition of employment. Applicability. The Industrial Disputes Act extends to whole of India and applies to every industrial establishment carrying on any business, trade, manufacture or distribution of goods and services, irrespective of the number of workmen employed therein. Settlement authorities under this Act. Settlement means a settlement arrived at in the course of conciliation proceeding and included a written agreement between employer and workmen arrived at otherwise than in course conciliation proceeding where such agreement has been signed by the parties thereto in such manner as may be prescribed and a copy thereof has been sent to the officer authorized in this behalf by the appropriate government and the conciliation officer. Unfair labor practices. No employer or workman or a trade union, whether registered under the Trade for Union Act 1926 or not, shall commit any unfair labor practice. Penalties. Penalty for illegal strikes and locked out. Any workman who commences, continues or otherwise act in furtherance of a strike which is illegal under this act shall be punishable with imprisonment for a term which may extend to 1 month or with fine which may extend to 50 rupees or with both. Penalty for instigation, etc. Any person who instigates or incites others to take part in or otherwise acts in furtherance of a strike or looked out which is illegal under this act shall be punishable with imprisonment for a term which may extend to 6 months or with fine which may extend to 1,000 rupees or with both. Penalty for giving financial aid to illegal strikes and lockouts. Any person who knowingly expend or applies any money in direct furtherance or support of any illegal strike or lockout shall be punishable with imprisonment for a term which may extend to 6 months or with fine which may extend to 1,000 rupees or with both. Penalty for breach of settlement or award. Any person who commits a breach of any term of any settlement or award which is binding on him under this act shall be punishable with imprisonment for a term which may extend to 6 months or with fine or with both. Categories of industrial dispute. The second schedule of the Industrial Dispute Act deals with matters within the jurisdiction of labor courts which fall under the category of rights dispute. To raise an industrial dispute, a workman can raise a dispute directly before a conciliation officer in the case of discharge, dismissal, retrenchment or any form of termination of service. Conciliation officers. The conciliation officers makes efforts to resolve the dispute through settlement between the workmen and the management. General prohibition of strikes and lockouts. No workman who is employed in any industrial establishment shall go on strike in breach of contract, and no employer of any such workman shall declare a lockout. During the pendency of conciliation proceedings before a board and 7 days after the conclusion of such proceeding, during the pendency of such proceeding before a labor court, tribunal or national tribunal, and 2 months after the conclusion of such proceedings, during the pendency of arbitration proceeding before an arbitrator and 2 months after the conclusion of such proceeding where a notification has been issued. During any period in which a settlement or award is in operation in respect of any of the matters covered by the settlement of award. Liquor is a liquid intoxicant deriving its intoxicating potency from the ethyl alcohol in it. Liquor can be divided into 3 broad categories, namely Indian-made foreign liquor, IMFL, beer and country liquor. Hard liquors broadly have alcohol content of and above 20% and denote whiskey, rum, brandy, the white spirits like gin and vodka, and also include country liquor. Soft liquors have a range of 4 to 20% of alcohol and include beer, cigar, wines and liqueurs. What is liquor licenses? A liquor license is a permit to sell alcoholic beverages. Liquor licenses granting authority. The application for the grant of license are invited through the public notice published in some of the leading newspapers. And applications for the grant of L1 license is required to be made in response to the public notice in the prescribed format together with its appendices B and C to the collector of excise. L3, L5 license in hotels. Department grants license to hotels holding star classification approval of Department of Tourism, Government of India. L19 license granted for service of liquor, beer in a club. The applicant is required to apply on the letterhead of the club to the Office of the Commissioner of Excise, and the accompanying documents are to be as registration certificate in respect of club, L19 license granted for service of liquor, beer in a club. The applicant is required to apply on the letterhead of the club to the Office of the Commissioner of Excise, and the accompanying documents are to be as registration certificate in respect of club. L20 license is granted to licensed hotels, restaurants and clubs for service of foreign liquor inside or outside their licensed premises on temporary basis for hosting a function on a specific day. Now in the end, let us summarize what we have learned in this lecture. The main object of the legislature in the enactment of Consumer Protection Act is to provide for the better protection of the interests of the consumer and to make provision for establishment of Consumer Council and other authorities for settlement of consumer disputes and matter therewith connected. A key change relating to contracts is that the Act forbids the automatic renewal of fixed-term agreements. Once such a contract nears the end of its term, one has to give the customer notice and on expiry the option to renew it for another fixed term, change the terms or cancel it. A person is not a consumer if he purchases goods for commercial purpose or resale purpose. However, a person is consumer if he or she purchases goods for the purpose of earning his livelihood by means of self-employment. The procedure for prior permission of appropriate government for laying off or retrenching the workers or closing down industrial establishment, unfair labor practices on part of an employer or a trade union or workers. Industrial disputes are symptoms of industrial unrest. Industrial unrest may take either unorganized or organized form. When it is unorganized, it is manifested in form of low morale, low productivity, frustration, etc. Organized form of industrial unrest includes strikes, demonstrations, boycotts, etc.